Rule 118 or pre-trial. So this is a mandatory a proceeding held immediately after the arraignment of the accused. If he pleaded not guilty in a non-capital offense. So, ayan pala, Section 1. Pre-trial is a mandatory in criminal cases. In all criminal cases cognizable by the Sandigan Bayan RTC MTC, the court shall, after arraignment and within 30 days from the date, the court acquires jurisdiction over the person of the accused unless a shorter period is provided for in special laws or circulars of the Supreme Court. Order a pre-trial conference to consider the following. So what are the matters taken up in the pre-trial? 1. Plea bargaining, stipulation of facts, marking for identification of evidence of the parties, waiver of objections to admissibility of evidence, modification of the order of trial if the accused admits the charge but interposes a lawful defense, and such other matters that will promote a fair and expeditious trial of the criminal and civil aspects of the case. So, pre-trial agreement, Section 2. All agreements or admissions made and entered during the pre-trial shall be reduced in writing and signed by the accused and his counsel. Otherwise, they cannot be used against the accused. So, the agreements covering the matters referred to in Section 1 of this rule shall be approved by the court. Okay, so, dito rin kasi sa pre-trial nangyayari ang, ang court annex mediation. Pero for the following cases lang. If the case is BP 22, and by estafa, syempre theft, and reckless imprudence, but for the civil aspect only, and fifth, violation of SSS law. So, question, may the pre-trial be held despite absence of the accused and the complainant? Pwede naman. Yan. So, non-appearance at the pre-trial conference, Section 3. So, if the counsel for the accused or the prosecutor does not appear at the pre-trial conference and does not offer an acceptable excuse for his lack of cooperation, the court may impose proper sanction and penalties. Pero hindi yan yung sinasabi ko kanina. Paano kung yung accused or yung complainant ang absent? No? So, pwede ba yun? Pwede yan. Kasi nga, ang nire-require ng Section 3 ay yung counsel for the accused and yung prosecutor to be present. No? So, pwedeng wala sila, can be absent, provided that the counsel for the defendant, for the accused, and the prosecutor are present. Okay, so Section 4, last section for Section 118, yan, pre-trial order. So, after the pre-trial conference, the court shall issue an order reciting the actions taken, the facts stipulated, the evidence marked, and such order shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during trial, so unless modified by the court to prevent manifest injustice. So, that ends Rule 118.